All right, everybody. Welcome to another episode of the Discovering Multifamily podcast. I'm your host, Anthony Scandariato with Red Knight Properties. And today we have a very special guest here with us, Steve Wallace, who is the founding attorney of the Wallace Law Group. He's in the West Palm Beach area of sunny Florida, one of my favorite states, and has over a 20-year legal career. And he primarily focuses on commercial and residential real estate and business transactions. He's done distressed transactions, bankruptcy, and other commercial litigation matters. But today we're going to talk about due diligence practices as it relates to specifically apartment buildings, multifamily, in general, what you need to look for as a buyer, as a sponsor, as an operator, and also from the lender's perspective, whether that's through an agency lender, what that means is it's backed by the federal government, Freddie and Fannie Mae, or from a local bank or a bridge lender. So he's going to provide some pretty interesting perspectives on what they look for when underwriting a commercial multifamily transaction. So Steve, thanks for coming on the show. We appreciate it.
Thank you so much, Anthony. I appreciate it.
Great. So when what do you represent a variety of different clients, but for on the multifamily side, for a multifamily operator, whether they're just starting out or they're experienced and they are looking at, deals that are very different price ranges. So anywhere from $1 million to $100 million. Mm-hmm. Does the process of due diligence change depending upon how big the deal is?
I mean, I generally, sorry to interrupt you, Anthony. I generally, when I'm representing a client, I try to, I don't look at the dollar values, and I always try to, generally what we do is, ideally, we're involved in the negotiation of the contract, because it's also very important to put in your contract certain requirements and the ability to, conduct an extensive due diligence on the acquisition. Generally, we have a standard checklist, which I'm confident that we'll walk through today. But I generally treat every transaction the same. We try to have all of the same requirements that we would have for a $100 million transaction for a $1 million transaction. Certainly, oftentimes when you're dealing with non-institutional investors, especially like a mom and pop type of owner of a smaller multifamily, they may not have all the records and the documentation that we're looking for, but certainly we try to approach everything holistically and employ the same techniques on each type of transaction.
Awesome. So could you talk about a contract? So what's the process for a multifamily operator when they evaluated a property, they underwrote it, which means they conducted their own financial due diligence to see if the project's even feasible to move forward with an investment? The next steps would be making an offer, and then what we know as the PSA, or purchase and sale agreement, gets put together, which I'm sure you help out with. Mm-hmm. What are the typical terms for due diligence that you see for multifamily projects in terms of timing and some of the other common terms you see?
I mean, oftentimes there's market guidelines as it relates to timing, but generally I don't feel comfortable having my clients have anything less than a 60-day due diligence. But certainly, depending upon what the market forces are, how much inspections and due diligence they've had before the finalizing of the offer and the PSA, 60 days gives you enough time. And here's some of the reasons why. We need to review the title insurance commitment and the exceptions. We need to get a lien search and an open permit search. We need to get a survey. We need to get a third-party zoning letter, which they provide, which provides the zoning per the municipality and parking spaces, ADA requirements, and some other requirements that institutional lenders are looking for. We also always need at the least a phase 1 test. And then depending upon what the phase 1 test tells us, we may do a soil borings test as well as a phase 2 test. The reason why we ask for 60 days is because we're relying on outside sources, and generally, a lot of these reports, it takes at the minimum 20 days, and oftentimes, depending upon what the workload is, it could be anywhere from 30 to 60 days. So that's why we need all of those timeframes, as well as engaging your outside structural engineer to review this, to do the different physical inspections that you need as well.
Sure. Have you ever come across where sellers want a really reduced due diligence period and it's a competitive market where you've seen due diligence periods, you mentioned 60 days, being much shorter than that?
Absolutely, and especially when we're dealing with non-institutional owners of properties, their goal is, especially if there's a bidding process when we're dealing with multiple offers, certainly their goal is, and I've actually seen situations where sellers will not allow any type of due diligence. It's a pure as-is transaction, and they tell all the prospective purchasers, do your due diligence up front, and then when you're ready, sign a clean contract and move forward. And I generally will advise my clients against those, but again, ultimately becomes a financial decision. All that I'm here as an attorney is to protect them against themselves most of the time and evaluate all those risks that are involved in the transaction.
Got it. So besides the due diligence from a timing perspective, and you mentioned what goes into that time frame, there's a lot of work that needs to be done. Are there other common purchase and sale agreement terms that you see a lot of other attorneys maybe overlook or operators kind of overlook? I can, give you one, for example, which would be the sunset period in terms of environmental lookbacks, being 2 months. Sometimes the seller would want, and not really budging and not really understanding why you need more time on that. Are there other provisions that get overlooked as well a little bit?
Yeah, sure. Well, a lot of what attorneys get involved in is there's a certain section in the contract called representations and warranties. And a lot of those are just asking the seller to make certain representations as to certain conditions of the property, the financial conditions, if there's any, moratorium on development, if there's any type of code enforcement issues, if there's any changes in use, any types of things like that. So I would say, the representations and warranties are sections that, I take a real careful look at. And that's what leads to most of the negotiations. Also, timing, I can't stress enough how important timing is, because in addition to reps and warranties, there's conditions precedent to closing. And oftentimes a seller wants you to, the minute you sign a contract, they want you to close. But if I'm representing a buyer in a transaction, I need to make sure that we get all the documents that we need to make an evaluation of the property. Like, I'll give you a couple examples. When we're talking about verifying the financials, you can do the financial underwriting, but what we won't know until we go nitty gritty into due diligence and request tenant estoppel letters and SNDA documents. We need to know, for example, how many tenants are past due rent. Especially, it's even more important now because of the COVID, where there's a lot of tenants in a building where they haven't paid rent or they're on some type of modification. So you can look at a financial at a P&L for the property, but who knows how updated they are. And I'm sure that a lot of sellers don't want to really shed light on what the collection vacancy rate is right now, from March until currently, especially in your area, New Jersey, where still a lot of things are shut down. So one of the things that we see, and it goes to negotiating, is I always want to get signed tenant estoppel letters by the tenants. Oftentimes, based on, just certain requirements or certain scenarios, that may be very difficult. And oftentimes a seller, instead of signed tenant estoppels, will try to give you a certified rent roll. And even that, though, will have inaccuracy, especially if we're talking about, 100+ unit building. It's very difficult to tell what the true story is. And then oftentimes we were negotiating back and forth. Well, if there's evictions going on in the property, especially if you're looking in a value add situation where you're going to go in and it's a mess, the property, at least the tenancy, and you're looking at as value add and going in and trying to clean everything up and raise the rents, which a lot of your investors, I'm sure, on the show do. You really need to know what perils you're buying in. I mean, myself as an attorney, I know you're very experienced in multifamily. It may not be something that we're afraid of doing, but certainly for a novice investor, it's going to be difficult to evaluate, because the last thing you want to do is buy a bunch of lawsuits.
Exactly. No, that's very well said. Can you talk a little bit about it from the lender's perspective? You mentioned a certified rent roll. I've had to sign certified rent rolls before that I had to represent and the seller had to represent at closing, which obviously post-closing it changes, especially when you have a value add property. Can you talk about some of the other things, particularly maybe Freddie, Fannie Mac looks for that maybe other lenders won't look at to finance larger multifamily properties?
Sure. So the agency loans, which are Fannie and Freddie, have some different requirements. A lot of what they're looking for is what the corporate structure is of the purchasing entity. They look at a lot of, how, if assuming the deal is, if there's a syndication going on, they want to see who's really in control of the property. The other thing that they're concerned about, and I've represented a bunch of lenders in lending on these transactions as well. And so a lender is always looking for the perspective of what happens if the borrower doesn't pay and I have to take over the property. What really am I inheriting? So oftentimes there's a requirement that the borrowing entity is going to be a single purpose bankruptcy remote entity. And generally they want that entity to be a Delaware entity. And they also, depending upon the nature of the borrower, they also want to have an independent director appointed under Delaware law to protect the lender in the event there's any dispute over ownership and any type of lender liability issues that would entail if there's a foreclosure and they're trying to take the property back over. Additionally, there are a variety of required third-party reports, like Fannie and Freddie require you can't just go to the municipality and get a letter from the municipality certifying the zoning and the parking spaces. They want third-party reports from institutional providers. They also are looking very carefully at the survey, the title insurance policy. They look very we're always looking very carefully. And I do this the same way on the buyer side, but they're always concerned about what issues are going to pop up if we have to take over the property. They look very carefully at parking spaces to make sure that there's enough parking under code. And oftentimes, especially if you're dealing in an older property, like a B or C property, sometimes there's not enough parking under the code. And it also comes into play when there's extensive rehab or additional construction to an existing property. The first couple buildings of the multifamily, if we're talking about a larger complex, they may or may not be up to code or current code. And then the other thing we're looking at as a lender, and this is always a major issue when it comes to underwriting these types of properties, is what's going to be the capex. They want to make sure that there's enough money in escrow or enough money in a net or set aside. So in the event that there's any capital improvements to the property and for some reason, the borrower doesn't pay, there's enough money that the lender can go in and make the necessary rehabs to the property.
Sure. And is that just Freddie Mac or Fannie Mae, or do other lenders require?
It's absolutely required by Fannie and Freddie. But again, it goes to the size of the loan, and also and also many non-recourse loans require these types of things.
Got it. Can you kind of talk about the size a little bit? So in order to do a Fannie Freddie loan, do you have to have a certain loan amount in order to be considered?
Yeah, they're always changing, but I think the guideline is it has to be at least $20 million or up. I know that they have some other smaller programs. I believe, again, I'm not a loan originator, but I think the minimum loan amount you can have is $5 million, and that's on their small balance sheet loans. But most of the deals that I've handled are $20 million and up.
Yeah, you can actually have $1 million, which is interesting. This is very small. I believe it's Freddie Mac small balance program in loan size. So is pretty amazing. So we kind of talked about just physical and due diligence, and then lender due diligence. Can you talk a little bit about financial a little bit more, digging into that? So if a seller makes a rep, then the buyer already closed and, figures out there was a huge miscommunication. Maybe there was a CAM charge that they were underwriting and it wasn't true. What kind of recourse does the buyer have to the seller? Like you mentioned evictions too, maybe evictions that the seller didn't represent.
Mhm.
And let's say there's 10 of them at a 50 unit property, and that's basically almost 20% of your rent roll. So
Mhm.
what kind of recourse do you have as, a borrower who already closed?
Well, let me just back up 1 second as relate to that. So generally, during due diligence, hopefully, ideally, we find a lot of these things. But if there's any type of concern, what we generally do is we'll set up an escrow account, and we'll set up an escrow account, and then basically put the money in escrow. And generally, I always try to have at least like a 3 to 6 month time frame. So even for post closing, we're able to have that basket of money ideally to draw against. Now, in the event it's something where my clients and I are totally misled by the seller, there's a possibility that it's totally missed. And very, thank God for in my career it's happened. I can count it on one hand. So then ultimately what you would have to do, and this goes again to negotiating the contract, is how long the representations and warranties are going to last post closing. So, and you talked about that earlier. If I'm a seller, I want to have it done the day after closing. I'm done. There's a clean break. Traditionally, we try to, and again, when we're dealing in a commercial transaction, everything is up for negotiation. But traditionally, we try to have a 12-month period. Now, again, I will never ever let my client close on a transaction on any less than a 6-month look back. But ideally, we have 12 months, or if there's some major concerns, we push it out to 24 months.
Yeah, 24 is very tough to get.
Yeah. I mean, 12 is pretty much the standard. Depending upon, again, how motivated my buyer is, especially if there's some value that they purchase the property, I'll let them go down as low as 6. But ultimately, if there's a situation where we find all these things out post closing and there's not a basket of funds to draw against, then we would have to file a lawsuit in the county where the property is located. For breach of contract, would be a breach of representation and warranties.
Have you
And
had a lot
ideally,
of?
sorry, let me just finish. I apologize. So ideally, the seller is liquid. So oftentimes we're dealing in a situation where there's a single purpose bankruptcy remote entity, and generally post the representation period, it's oftentimes where the minute the closing occurs, everything's distributed to the partners, and there's nothing to go against. So I'm sorry to interrupt you.
No, no problem. I was just going to ask you, have you had many post-closing disputes and have actually had to go to trial around?
We have, I mean, generally I handle kind of some simple like litigation. Like I do a lot of commercial and residential evictions for clients, and I've done foreclosure and foreclosure defense. I've had some of those post-closing disputes, and generally if it's something like I usually handle it up to trial, and then I'll bring somebody in, like we have a trial lawyer in our firm that'll finish it off. But there have been situations, I mean, especially you said how much you love sunny South Florida, but I can tell you that it's not the best place to do business because we have a lot of unscrupulous characters, and oftentimes people will come down here, to escape whatever they were escaping up north, and
Right.
they try to set up shop down here. So the concern we always have is collection, because we can go through trial, we can spend 1 or 2 years in court, go to trial, and then we can paper our walls with a judgment that's not enforceable. But there have been situations, I mean, generally speaking, we always learn from, issues that happen in other transactions. And I'm always trying to strive, to draft the perfect contract. But if any lawyer tells you that a contract is airtight, they're absolutely misleading you, because there's always other things. Like, for example, with the COVID thing, we always have, like in leases and in contracts, force majeure. And so now a lot of business interruption insurers are denying it because they're saying, oh, that's not an act of God. That's not a government shutdown. And so there's going to be one thing to look for on the horizon is there's going to be a lot of business interruption insurance lawsuits, bad faith type of lawsuits or breach of contract lawsuits as a result of that. So we're always learning. We can never have the perfect contract. I have my standard contracts that I use as a starting point, but I'm always updating them.
Sure. No, it makes a lot of sense. And it's important to, whether you're buying large commercial real estate or even on a small scale, to align yourself with a good attorney like Steve, who is pretty experienced, because, there's not many good attorneys out there like Steve, who really
Well, I
knows.
appreciate that. That means a lot for me because I know the experience level that you have. It means a lot, Anthony.
Yeah, for sure. And some of these provisions that we talk about, in my experience too, get overlooked, and we realize it after, and we're like, why didn't we really look at this? Because now we got ourselves in a little bit of issues, which we fortunately mitigated. But if you can mitigate that risk up front and hash it out between all parties reasonably, then that's a different discussion. So I'll kind of winding down the show just a little bit. So just about you personally, Steve, do you have a favorite business book or real estate book that you read?
Sure. It's funny you mentioned because I was just talking about with some people on LinkedIn about it. And I'll just give you a disclaimer right here. Although I don't necessarily agree with the politics that this person has going forward. One of my favorite real estate books, just because it's almost like a fantasy fiction book, is I love The Art of the Deal. Because one thing I can tell you is I'm a deal junkie. And so that really, just the descriptions and the behind the scenes discussions that took place in some of these large bellwether properties, it was very, very interesting and exciting to me.
Great book, for sure. And in terms of your hobbies, what do you do for fun?
Sure. Well, I enjoy exercising. I have 2 children at home. I have 2 small children. I have an 8-year-old son and a 4-year-old daughter, so they keep me really busy. When I was in middle school and high school, I played soccer and basketball. So now I'm coaching my son in those sports. And when my daughter's ready, I'll be jumping in there. I like reading. Like all of us during COVID, I'm kind of a Netflix binge watcher. So those are kind of the things that keep me busy right now.
For sure.
And I love the beach, of course, living in South Florida.
Well, definitely. How can people find you, Steve?
Sure. You can find me. I'm on LinkedIn. I'm on Facebook, and I'm on Twitter. At my Twitter handle is Wallace Steven 73. And then we have a very comprehensive website. It's thewallacelawgroup.com. Once again, thewallacelawgroup.com. And then we also have a YouTube channel, The Wallace Law Group, where I post some certain videos and instructional videos. And generally we have a new series that we've rolled out. It's called Ask an Attorney Anything. And I usually post weekly videos. And again, if you have any ideas or anything you're interested in, I'm happy to post a video on it.
Sure. And we're going to provide links to everything Steve mentioned in the comments section of our social media and also on iTunes in the description box. So Steve, really appreciate you coming on our show today. I think our listeners got something out of this for sure, at least I hope. But, one takeaway is you really got to understand your due diligence and make sure you do as much as you can up front, even prior to submitting your offer, even though it's very hard. But it kind of mitigates some further issues down the line when you actually do go under contract. So really appreciate you coming on, Steve, and hope to have you on again soon.
Well, truly a pleasure, and good luck. Stay safe, and hope your business remains profitable.
You too, Steve.
Thank you.
Thank you.